Why is a will important? Let's just jump right into it, man, because there's a lot of stuff to get into. Yeah. Why is a will important? And it can apply to anyone, right?
It can. Like we talk about this, and this is the reason I kind of got in this area of law, is that there's such a need for every person that you probably can think of, whether they're young or old or rich or poor or anywhere in between, because what you get to do with a will, obviously, it is your will. You then tell, once you've passed on, how you want your assets divided up, who you want them to go to, who you may not want them to go to, and then you get to decide charities and that sort of thing.
John, I've heard it called a roadmap for the court. To tell, basically, you're telling the court what you want done with whatever assets you may or may not have. And I think that there's some, people kind of maybe get a, misperception of, well, I don't have a lot, so I don't need a will. And that could be the furthest thing from the truth, right?
Absolutely. Now, you sit down with folks, like you meet with your clients, I meet with potential clients, and you do go over, what do you have? What is it that you want to specify goes to different people or doesn't go to different ones? And so you always have something, whether even it's just your intent and you want to spread kind of your post passing over intentions to your loved ones, because they want to know you were thinking of them. I mean, that's one first thing, right? That you were thinking of them, and they appreciate that. But then beyond that, you've got anywhere from, if you own a house, that's probably your biggest thing, and most people do, but even down to cars and bank accounts.
Well, you can be as specific as you want, or you can be as general as you choose to be. So like, take a musician, for example, probably has maybe a piano or violin or some guitars, and you can, direct the court who you want to receive those guitars, no matter what your spouse may say or what someone else may say. Say, hey, look, I want John to have my guitar collection. Well, if that's in my will, the court forces that to happen. And basically, it doesn't matter if you have a lot of assets, worth a lot of money, or don't have anything. A will is very important because it's a roadmap to continue your legacy of what you wanted your desires to be, because you can no longer speak for yourself and your will speaks for you, right?
And it's really important, like you say, a roadmap for the court to say what's going to happen, because there are statutes in place that say the basics of what's going to happen if you don't have a will.
Right, and so basically, I didn't mean to cut you off, but it's called testate versus intestate.
That's there you go, right there.
Pitching it back to you, tell us what intestate means.
Yeah, intestate means you don't have a will. Testate means you have a testament, a testimony even, as it were, what you want to have happen. So that's testate. Intestate means you don't have a will. And if you don't have a will, there's statute in place, and you can look it up, and it tells you exactly, or tells the judge exactly where things have to go. And it delineates down through family, and if you're married, that sort of things, there's certain requirements. But that may not be what you want to do. We have folks come in that talk about, well, I don't want anything going to this a cousin or this relative or my brother or my kids who ran off and left me. You can do those kind of things. Now, these are the bad situations. The other side is where you want things definitely to go that may not be included in that statute, and that's specifically when you have blended families. And this is a big one. And blended means you have kids and you're divorced and you remarry, and maybe your spouse has kids and y'all remarry. Now y'all have stepkids that y'all raise together, and that is that's your family. Well, if you pass away without a will, a lot of times it all goes to the spouse. Your kids now that have been cut off, your biological kids. And so you have to have a will to be able to delineate these kind of things, that I want to have some of it go to my biological children as well, or all of it, or however.
Right.
So those are it gets, like I said, a little more complicated as you sit down with folks, but a lot of people have these things these days, and it's a reality that we can help them with in setting a course for the court, to the roadmap of where things should go.
Right. Phone lines are open, 850-392-1544. You can always email us at lawcall@wmbb.com. John, what happens when someone has a will in another state that's, besides, that's not Florida? They move to Florida, and we hear this often, hey, do I need to get a new will? What happens then?
Well, whenever you locate permanently, you're going to reside here. We have a lot of military folks that come here, and the benefit of the military folks is they have their lawyers, the Judge Advocate General that does a lot of their stuff, and it will apply to a lot of things that they carry around. But that's at a federal level that they can create these wills that kind of have that exception. If you're moving here from some other state, there's sometimes what we call conflict of laws. And so if you move here from Alabama or Georgia or Tennessee, God bless you. You know, you come on down to the beaches and you want to be here. No, I mean, I admire Tennessee. I'm jealous of a lot of folks that live up there, but you want to take a look at and have a lawyer look at whether or not the way you have things delineated in your will from where you're moving from are what the courts in Florida might enforce. Because what's going to happen is when you pass away, again, it gets a little complicated, but that's why we're here. You look at where was that person residing when they passed, and where do they want to have the basis for the probate to take place. And it may say in the will, I may have passed away in Florida, but I still want my old state to do it. Well, that puts a lot of burden on your relatives who are living here. Your people, we call them personal representative, has to administer the state for you. It used to be called a testator or testatrix, which is a cool word, but now it's personal representative. But they'll have to travel back and forth from the other state. So you want to specify what that is. But the bigger question is the law going to be followed how it is in Florida the same as it is in where you left? And it may be better off. A lot of folks find Florida laws are a lot better for a lot of things, mainly for your home and for taxes. We don't have a lot of taxes here, so that's a good thing, and people want to adopt that. So we tell them, come in and let's review it. If you want to do it and you're interested, we can get you a new one. And then the other thing is, even if you got one, probably every 5 years, review it with a lawyer. Or if you have a life event, like you have another kid, or you get divorced, or
and you can update it, right?
Absolutely, and we just update it, right? Yeah, we're just looking to update what you already have, because that's a great start. If you already have a will, we don't start from scratch. We've got your intentions already, and we can move a lot quicker, a lot forward to get where you want to be.
So, John, to hammer this home, in civil litigation, when we file lawsuits, it's mandatory mediation that the courts impose for us to try to bring both sides together and mediate a case. And there's a lot of times that we hear from mediators that are trying to resolve these cases for our clients against the defendant. It may be an insurance company or an actual person, you know. And one of the main statements that they make is, think about this, you have the ability to control the settlement of your case. If you go forward and you go in front of a jury, at that point, you're taking all the control and you're giving it to the members of the jury to decide how to resolve your case. And they may be very, very generous, liberal-minded as far as, you know, a big award, or they may be very conservative and just not really understand the pain and suffering that you're going through, no matter how articulate the attorneys are. And sometimes things just happen, and basically you lose all control of the case, and it can be a crapshoot sometimes, right? And I guess having a will or not having a will is kind of the same thing. If you have a will, you're in control of everything that you've worked very, very hard to acquire and to keep. And there may be grandchildren, there may be friends, there may be, you know, former spouses or whatever that you want to give something to, and had you not had a will, those individuals wouldn't receive anything.
That's, yes.
And you lose, basically lose all control.
You lose any say in what's going to happen to your estate. And what you mentioned earlier, a phrase we like to say, is your legacy.
Right.
You know, you want to leave things to certain people who are going to carry on in the kind of the morals and the way of life that you support, or encourage them to do sorts of things. You know, sometimes people, I'm sure we'll get into it here, but other documents we can create are trusts or powers of attorney when you're alive and those kind of things. But they designate, what do I want if someone's they're a little misbehaving, you can try and encourage them as adults. Well, this money's going to come to you if you're behaving this way. One of the things that you pointed out, though, is that it is more in your control, you know, and you really get to lay that out. The statute is there as a backup, but there's a lot of things that get missed in that, because it's just, and you know this, it's just the basic framework of who gets what and when. But you can leave out a lot of things, and it's all set out, and it's all or nothing. They don't really split it up between folks. Like, you can decide when you sit down and write out your will. And the last thing I want to touch on here, and I'm probably coming up on a break, because I've been talking a lot.
Finish your thought, buddy.
But that, you know, when you're talking about what y'all do, and it's very valuable service, but hopefully not everybody gets in that situation. Everybody's going to need something, you know, when they pass. And this is, you know, whether it's a complex estate or not, we can adjust it to that too. You can make it a couple pages, or you can make it a book. You know, it depends on that. So,
phone lines are open. Give us a call, 850-392-1544. You can always email us at lawcall@wmbb.com. John, before we actually go to our break, we do have a caller online. We'll get to her, and then when we come back, we're going to jump into some power of attorney and trust commentary, I guess,
Yeah.
discussion. But caller, go ahead with your call, please.
Hello.
Fred, I can hear you, buddy. Go ahead with your call. Your question, I mean.
I'm calling. I'm an old fella, and I've got 2 sons, and I want to leave the house to them, and I was trying to find out about a revocable living trust and how to go about doing that.
Yeah, so I see here on the board that you're in Ashford, Alabama, which is a little bit different than Florida, obviously. Y'all do have some beautiful beaches, just not as many of them as us, right? But I believe that most of the states are similar. So I'm going to give you what we would do here in Florida. And what we can do is, if this is something you would like to follow up on, we can certainly give you a reference to an Alabama lawyer or talk with you a little further if you've got some Florida contacts that we can bring jurisdiction into it here. But yes, if you just have 2 sons, you're not married at this point, what we can do is a lot of different things. One I'll throw out there is called an enhanced life estate, which is where you still keep the house, but when you pass, you would leave it to them specifically. It's also called a ladybird deed, is a real pretty name for it. But then as far as the trust goes, you could actually use that type of enhanced life estate, a ladybird deed, to keep possession of your house, manage it how you want, and then once you pass, it will then go into a trust. And at that point, you have kind of control over, like we said, with kind of your principles, your legacy on how you want this house to be either kept in the family, whether you want it to be split up if they want to sell it, whether there'll be conditions on kind of what they do with it. So that's what a trust can do. But that is a good question. That's a great way to kick off what's going on here. But yeah, I think Alabama usually has most of the same things we do, but we would want to get specific
Well,
to
I know
that.
there's a difference in the homestead exemption
Absolutely.
law as well. And so, Fred, that would be something very specific. But we'll be glad to make a referral to you and kind of give you some guidance for an Alabama attorney who can navigate that. Phone lines are open, 850-392-1544. Always email us at lawcall@WMBB.com. We're going to take our first break of the evening. We'll be back in just a moment. And welcome back to Law Call. Tonight we're talking about wills and trusts and estate planning. I've got my good buddy John Maslick with us tonight, and we're going to jump right back into it, John.
Yeah.
But I think we do have an email that came through during the break, and let's see here. When my mother died, her house, which had been her parents, passed to me and my sister. I signed the home over to my sister because she was living in it at the time. My sister has now passed without a will. She told me when she was in the hospital she wanted the house to go to me. However, her son recently got out of jail and was staying in the home when she passed. And without a will, I'm assuming that I don't have any legal options to make a claim on the home. I know he won't make mortgage payments and it will end up being foreclosed on. Do I have any options to keep this home in my family? Anonymous call.
Ooh, that's a good one. This is like a law school question, man. I like it.
That's like a bar exam question.
Yeah, it is. So, yeah, issue spotting. What do you see there, Chris? Where you want me to go on that?
Hey, you're the expert in this
Okay.
now. Well, I don't know if dying declarations are important.
They come into play
in situations like that,
sometimes,
like you would in criminal law.
Yeah.
But you basically have a surviving son, and it's going to be intestate, number one. Because there's no will, right?
There's no will. That's
and
right.
so you have
Coming back to that.
a surviving son. Are you quizzing me up on this?
I'm putting you on the spot a little bit.
Oh my goodness,
You're doing
man.
good. You
All
got
right,
the
man.
first one, the intestate, and you got
pass
dying
it.
declaration.
I'm
That's
passing
fun.
it back to you, man.
Okay.
You're the expert in this.
So you're on the right track, and I will tell you what, the dying declaration is something that's, I'll just touch on it, doesn't come up very often. I mean, they're usually really hard to get into court. You need multiple witnesses and all sorts of things, and then even then it may not carry any weight. To back up a little bit, what this is going to entail, unfortunately, is probate, which is where you have to still bring it in front of the court, take it to the judge, and they're going to delineate out how this case is going to be resolved. How is the house going to transfer? Because it doesn't go automatically. With the last caller we talked about from Ashford, that would be automatic if you had that kind of deed language in there, that in hand life estate, that ladybird deed. This is just a regular deed, I assume. It's something you would have to have a lawyer review, because that deed you may be able to go back and look at, was this a valid transfer of your father's portion to the sister? Maybe he's still got a claim that you can bring back up. But these are all contested probate topics that are going to unfortunately cost money as the lawyer fees and the court fees add up. Now, beyond that, getting to the heart of the matter, which is really, is there anything that can be done? Beyond, obviously I say there's things you can look at to fight, but is there something with as far as how it descends? If you're just looking at the statute, if your sister is the sole owner of the property and she passes, ultimately the court is going to follow that statutory roadmap, which is not the one that's written in a will, but just statutory, and it's going to end up going to her children. If she didn't have any children, it kind of goes back up is the sequence to her parents. If her parents are passed, then it goes out to her siblings, and then you might come into play. I'm just pointing that out as that's kind of the sequence on a statute. If your nephew's alive, obviously that's going to be the way it descends down through the court process. But you could potentially get a lawyer that is going to kind of fight that, look at it, see if there's any legal points that can be brought up to the court, like the dying declaration, or maybe the deed originally didn't get executed properly, that you could still have a claim to it. And then lastly, long shot, maybe the house does get foreclosed and you can get down there and buy it for that with the bank. But I wouldn't, that's really risky going that route. So
well, here's what I just learned. Thank goodness you're my buddy and you know this stuff. Okay. My goodness. John, one thing that came to mind when you talked about how costly it could get, you're talking about thousands and thousands of dollars and a lot of billable hours, I should say, man hours, trying to figure this out, trying to represent someone where it's probably the better result, right? You're talking about thousands and thousands and thousands of dollars to prosecute that and contest this. Now,
you sometimes need witnesses and expert fees.
Doing a will in a situation like this is probably, I don't know, a couple grand, thousands, something like that. Just basic.
It's completely different numbers. You're adding zeros when you're doing litigation. Correct. Right. Yeah.
Okay. Yeah. Right. So, by all means, like we said earlier, be in control, spend the money now, you'll save it later, right? Phone lines are still open, 850-392-1544. You can always email us at lawcall@wmbb.com. We do have a caller on the line, Cindy from Panama City. Go ahead with your call, please. Cindy, go ahead.
I can hear the TV going.
Cindy, you may have to turn your television down to hear us. Can you hear us? Okay, we're going to have to drop that. We'll move on. John, I do have a question for you, though, real quick before we take our last break of the evening. Power of attorneys. And a lot of people throw that around, and they're like, oh, I have a power of attorney. I don't need a will.
Right.
Well, we know what happens at that. But so let's just take while the person's still living, 45 seconds or less, why does someone need a power of attorney?
All right, so first off,
power
of attorney gives someone, while you're alive, gives authority to someone, we call your agent, to act on your behalf for legal matters. So dealing with the bank, dealing with the house, maybe selling your house for you if you're incapacitated, and that's when it comes into play. They stop in Florida. A power of attorney ceases to be effective upon your death. So that agent can no longer act on your behalf. You may have dealt with that when you buy a house. Sometimes you give a limited power of attorney to folks, but that's the big difference. The next thing is you should definitely have one, because it comes into play not just, well, I'm not doing well and I'm kind of, my grandma's going into the nursing home and she's kind of slipping a bit. That's one thing, but also it can happen to spouses, and you should have it for each other just to be double safe, because sometimes they may be in a car accident and they're just unconscious for a few days. You might need to deal with some things.
Now John, you brought up grandmother. If you're incapacitated and deemed to be, not in sound mind, you cannot give someone authority over you at that point. It's too late.
That's correct. It's too late at that point. Yeah.
So phone lines are still open, 850-392-1544. You can always email us at lawcall@wmbb.com. We're going to take our last break of the evening, and we'll be back in just a moment. And welcome back to Law Call. We're in our last segment of the evening, John, and I know that we've got a caller on the line. We're going to try to get that question and see if we can get something answered there. So go ahead with your question, Rebecca. I believe it is from Bay County.
Yep, there she is.
My dad and them was dividing up their homestead, and all the brothers were supposed to sign off of each other's property. There was one brother that was overlooked, and he did not sign off of the other's property. The brothers thought that everything was clear, so my dad signed the property over into mine in his name, and then when my dad passed away, I went down and had it moved over into my name only, and when I ran a title search on it, it showed that one of the brothers had not signed off of it. Well, since then, that brother has passed away, and there was no will left. The only thing that I understand is that there was a letter that was wrote that all of his property was supposed to go to another brother. How would I get my piece of property straight now?
So Rebecca, just real quickly, we may not can get to all of that question, and if you can, we're running out of time here, but we will give you a shout and a call tomorrow and address this with you and get more information, because we're about to wrap up the show and run out of time. I thought we'd get it real quickly, John, but if you got 30 seconds if you want to say
I could do
anything.
a quick just summary and tell you that
20 seconds.
that what you're going to involve a lot of times, this is going to be in the probate process and trying to figure out, and the judge can help you with that. If you've had somebody passed already, sometimes you can have to open a probate for their estate to then execute that. But the first place I'd go is the title company, because sometimes they can guide you, and even that's why there's title insurance to deal with that.
So Rebecca, we'll try to answer that in further detail for you. We're trying to wrap up. I think we got a minute 30 left, John. You got a few shout outs?
I do.
I've got some pictures I got to throw up here.
Yeah,
and
so I'm going to shout out real quick.
Well,
do the pictures.
There's our boys right there in the clay shooting right there, and I believe Landon is in our next picture here. And there he is, showing off all those prizes. He's a sharpshooter, man. I mean, Donnie Chapman's grandson, but he gets it from his granddaddy.
I think we need to have that on the show as a closeout, maybe shooting some skeets.
No, you don't want to do that.
Close it out.
I'm going to give some shout outs here to Ashley, Boss Man. My mom's watching, Trey Smith, Judy Smith, Pam Myers, Donnie and Lisa Chapman, Landon. You probably need to be in bed, buddy. Ben Harris is watching, Rick from the Grand Marlin, and Gary Starr is watching.
Hey, Gary.
So what you got there? You got 30 seconds, wrap it up.
I got my brother's watching, I hope. Well, no, he's probably sleeping, knowing him, but I say hi to my brother Keith. I got my buddy Alan out there, my friends up there, and up towards West Bay. What's that place called up there?
They're your friends.
River
You got to know where they
Steve
live,
and Angel
John.
and Murphy back at the house, as well as Charlotte overseas. All right.
Same time, same place, different guest, and probably a different host next week. But anyways, thank you for watching tonight. Have a great weekend, and be safe, and good evening.
God bless you.